In the name of God, the compassionate, the merciful. Welcome, friends, to the 78th episode of Crime and Punishment, a legal podcast, not a political one. The official podcast of the Invictus Law Firm, PA, in Orlando, Florida. Odysseus has been jamming out to this medieval version of Gangsta's Paradise along with you. This is a nod to all of you who have been here a long time. We used to open the show with Gangsta's Paradise, but now that we're official and legitimate, we had to stop playing that song, even though it was a remix I did, because YouTube has a copyright problem. Oh, look. Got these papers here. I'm going to shuffle papers like Rush Limbaugh. When I was a boy, my father, your grandfather, used to have us listen to Rush Limbaugh every day, and he would always be at his desk shuffling papers, talking, just very mad, shuffling his papers all the time. I gotta bring that back. You want those? All right, why don't you take those papers and go to the library, okay? Speaking of the library, everybody, we're going to be reading from an Oxford book today. Let's see. Medieval Law and the Foundations of the State. Hence the remix today, the medieval remix of Gangsta's Paradise. My business coach is going to be super disappointed in me, but sometimes I just have to nerd out. I can't talk about Orlando news every week. It's very stifling talking about political news. We are not talking about politics, despite the title of this episode, Medieval Law and the Advent of Modern Politics. What we mean by politics is as the title of the book suggests, the foundations of the state. The state as an entity, the nation state, as distinguishable from a commonwealth or a city, right? We're going to talk about that concept, and that is what we mean by politics. We're not talking about Biden, Trump, Bush, Clinton, trannies in bathrooms politics today. We are talking about actual political theory as derived from medieval law. Odysseus, you're going to have to go to the library, or you're going to have to shushy. All right? You got to pick one. So, with this unprofessional environment, we shall proceed to the section titled State as Regime. I'm going to skip the introduction because there's a lot of inside baseball with scholars arguing over who cares, and I don't even know who these people are. So, please get out a pen. We're going to completely nerd out today. And I think half the virtue of this episode is just to introduce people to concepts they might not have learned in high school or even in college or even in law school. I went to law school, did not learn a thing about St. Thomas Aquinas or Carl Schmitt, mind you. Didn't learn any about Grotius or Pufendorf or any of the big names in international law or in legal theory. You learn about Hart and Dworkin. You learn about only those modern professors and quote-unquote legal philosophers who peddle liberalism. That is the only worldview that is allowed in law school. So even if you are a lawyer, even if you are college educated, even if you've been to graduate school, whether JD or PhD program, you might not know any of this. So this is for you, the fellow nerds out there. Not talking about the news today, although it is interesting that this whole Patriot Front thing going on, just to date this episode. They did their march on Washington, D.C. I think it was this past weekend. And now Twitter's afire with all these people are feds. And why? Because conservatives are suspicious that a group of young men would be physically fit and well organized. Well, obviously a group of young men who are physically fit and well organized with a political message would be feds. What does that say about conservatives, by the way? That if you're young, physically fit, you have a political hard line, and you're well organized, that you must be a fed, because no real people can do that, right? And I see all these comments on Twitter about, well, I've never met anybody in Patriot Front. Nobody I know knows anybody in Patriot Front. Well, maybe because you're not elite enough to be in Patriot Front. They don't allow fat bodies. They don't allow conservatives. You wouldn't know them. But to say, I don't know them, therefore they don't exist, how many CIA agents do you know? How many NASA astronauts do you know? A bad example, because they actually are with the federal government. But the point is, you don't have to know them for them to exist. And I pointed out to one commentator, he said, I'm very well connected in the right wing. Never met anybody in Patriot Front. Don't know any of them. Therefore, they are feds. I'm like, well, I've been in the right wing for a long time. Not anymore, because I don't have any political opinions. This is a legal program. Never heard of you, conservative talk show guy. And I have personally known numerous members of Patriot Front and have represented them in court. So are you a Fed because I know them and I don't know you? It's a ridiculous argument. But not quite as ridiculous as, well, they're young and they're super in shape and they're well organized, therefore they can't be real people. Insane. The other big news that we're not going to talk about is Dr. Taylor Marshall running for president. God bless him. Now, we're going to completely divert away from the news and we're going to read about medieval law and the foundations of the state. So, get your pen out just so you can write down the names, the authors, the concepts, and you can look this up on your own time. This is going to be kind of a tour de force of political theory today. The usual meaning of state has come to be the regime that commandeth the rest, so that in the 20th century, the Commonwealth requires to be distinguished by the hybrid term nation-state. This sense of state was forged by Italian humanists, who sought to understand the changes of regime of their cities, the mutazioni di Stato, during the 14th and 15th centuries. In the England of the 1530s, during Henry VIII's political reformation, the dialogue between Pole and Lupset that the Italian-educated royal chaplain Thomas Starkey weighed up the virtues of government of the state of the commonalty by a prince or by certain wise men, or by the whole multitude, concluding unremarkably that a princely state was most convenient for our country, that is, England. A lot to unpack there. Henry VIII being, of course, the arch-heresiarch who broke from the Catholic Church and established the C of E, the Church of England, so that he could divorce his wife, marry a new woman, so that he could produce an heir for the throne. A major political development as well as a religious one. And of course, his daughter taking over the throne, major development as well. In the midst of the French wars of religion, Montaigne looked to Machiavelli's Discourses on Livy as an authority on mutations, like those which were convulsing his country in the 1580s, though he proclaimed it folly to seek to upset the existing regime and to change the government of a few into a popular state, or a monarchy into something else, in the hope of improving the situation. So they're talking about the evolution of governments, something that Americans have not figured out happens in real life, and will happen here. If you've read Machiavelli's The Prince, you know that he talks about the difference between republics and principalities, between those city-states that are governed, or governments that are governed by a prince, and those that are governed by the people. We here in America tend to think that this is a republic, it's always been a republic, it's going to die a republic, and it will die a republic, and it will turn into something else. That's the funny part. But we seem to think that it's just going to go on, and on, and on forever. We are seeing the fall in real time, right now. And the question is, who's going to pick up those pieces, and what is it going to turn into? Everybody's lamenting, not everybody, but the vast majority of people are lamenting the advent of strongman politics as though it's something you get out of. It's like lamenting the fall, the coming of winter. It's like being in winter and lamenting that it's going to be spring soon. It's just, this is what happens. And so Machiavelli's Discourses on Livy which you should look up. Montaigne is another one to look up. The Prince, I don't know how you haven't read The Prince. These things talk about those mutations or those evolutions of government. Odysseus. Last chance. Machiavelli's Discourses, printed posthumously in 1531, had analyzed the regimes of the city-states in terms of three stati: Principato, Ottimati, and Popolare, and their perversions, Tyrannia, Stati di Pochi, and Licenza, showing how one could slide into another and how a free state, uno stato libero, might emerge from the tumult. Though born of the experience of Renaissance Italy, and particularly of Florence, of which Machiavelli had been second chancellor from the fall of Savonarola in 1498 until the return of the Medici on the coattails of a Spanish army in 1512, both the Discourses and the Prince set their analyses within the political categories monarchy, principato, aristocracy, ottimati, and democracy, popolare, created by Aristotle in the 4th century BC and recovered in the 13th century by William of Moerbeke and Thomas Aquinas. William's translation of Aristotle's Politics around the year 1260 and St. Thomas's commentaries upon them constituted a turning point in the history of European political theory. A lot to unpack in that paragraph. Where to begin? First of all, you should write down the names of Machiavelli. If you haven't already, you need to read the Discourses on Livy and the Prince. Another name of note is Savonarola. So Machiavelli became second chancellor from the fall of Savonarola. I won't name names. I had a talk with a guy who was a politician in a state I won't name. And I remember when I got out of JAIL and I talked to him about returning to the Catholic Church, and he was all about it and said that publicly he, is a Christian, has his talking points, but privately he is pure Savonarola. He's an absolute Catholic fanatic. You should look into him as well. Also popularized in the European series Borgia. The Medici, famous family in Italy. Aristotle, of course, they're talking a lot in this book about his politics, his book, Politics, and St. Thomas Aquinas, who we don't talk about nearly enough. Speaking of Dr. Taylor running for, Dr. Taylor Marshall running for president. So let's actually look at the chat. I never do that enough. Remember when you ran for president with epic aesthetics? I do remember that. I do. But Big Brother is one out. We love Big Brother. We support anyone who's in power at the moment. Please don't ban us from YouTube. In his discussion of government by one, a few, or many in the treatise De Regimine Principum, which he was writing within half a dozen years of William of Moerbeke's translation, and in the more detailed commentary on the Politics, which he began in the year 1269, St. Thomas Aquinas used the Latin Aristotle's monarchia, aristocratia, or oligarchia, and democratia, to refer to the various types of government individually. When he wished to refer to these political forms collectively, he employed such terms as polity, dominion, power, and rule. And this is how you know this guy is C of E, possibly. He calls him Aquinas, not Saint Aquinas or Saint Thomas Aquinas. I would use this part of the lecture to encourage everybody to learn Latin. If you're writing down all these names, write down learn Latin. I'd say learn Greek, but I haven't learned Greek, and I'd feel hypocritical telling you to do so when I haven't. But when the Ottomans took over Greece and they extended their empire into the Christian lands, right? The Orthodox, the Christians, set these so-called secret schools, these underground schools. So they would homeschool their kids away from the empire, and they would teach them not only the old Christian rites, but also Latin and Greek. And if you look at all of these revivals of ancient cultures, look at the Gaelic revival in Ireland in the late 19th, early 20th century. Look at the revival of Judaism, right? The establishment of the state of Israel. You see, they knew that in order to do these things, either the Gaelic revival or the Jewish revival, it all depended on language. And one of my theories about the fall of the Catholic Church is that's exactly why they took out Latin. That's exactly why it's no longer the language of the elite, of scholars, of those in power. It's because they knew that if they took out Latin from the Catholic Church and from all governments, from the legal profession, from the medical profession, it falls apart. These people doing their revivals, they knew that the strongest solidifying factor was language. And so when the Ottomans took over, those Orthodox Christians knew that they had to preserve their studies in Latin and Greek. So note to self, I need to learn Greek, but you should really learn Latin and possibly Greek. It has been shown that it was not Aquinas himself, but Louis of Valence in the version of St. Thomas's commentary, which he published in 1492, who substituted the terms state of the best, optimatum status, for aristocratica, state of the few. So that's one. He substituted the term state of the best for state of the few. He substituted paucorum status for oligarchia, and he substituted popular state, populari status, for democratia, having found the new terms in Leonardo Bruni's early 15th century translation of the Politics. So today we just call these, monarchy, aristocracy, democracy. Easy day. But there was actually a long period of time where these terms were all being developed. They were being developed by lawyers, legal philosophers, these people who were reading Aristotle, these Catholics, by the way, who were reading Aristotle. That's where Western civilization itself comes from. Nevertheless, it seems to have been Aquinas who took the simple but momentous step which would focus the understanding of Italian city politics, and subsequently the politics of the kingdoms of the rest of Europe, on the state of the regime, status regiminis. He formulated the concept of the state as the set order of the governors at the heart of every stable commonwealth, the general concept which was necessary before the name could be attached to a particular form of government in Aristotle's scheme. In the first part of the second part of his Summa Theologica, which is probably contemporaneous with the commentary on the Politics, Aquinas discusses the relationship between the law of the Jews in the Old Testament and the new law of Christ. How much of the old law is still valid? He concludes that the judicial precepts binding the Jews lost their force with the coming of Christ and the changing of the state of that people. Mutato stato ilius populi. Another major shift in perception between our modern understanding of politics and the medieval understanding of politics. Everything was Christ-centered. Today, what is the anchor? What is the central governing concept? It appears to be the will of the people. But even that, you talk out of both sides of your mouth, because both sides of the country, the Republicans and the Democrats, the Republicans are saying, will the people this, red slide that, and Donald Trump was elected by all these people. At the same time, they don't care about the will of the other half of the people. Likewise, the left wing, they talk about the will of the people, and we got to get more, immigrants in here, and these elites in the Republican establishment, they don't care about the actual will of the people. Who do they really represent? They're both talking out of both sides of their mouth. Neither of them really mean that. What they really mean is, we want all the resources, we want the power, we want to be the governing force, and we want you out. The will of the people is just a talking point. And maybe the Senate could say that Christ the King was a talking point, or at least it became that way. I think if you read Diplomacy by Kissinger, he talks about Richelieu and the concept of realpolitik. And he talks about how all of medieval Europe had this governing concept of Christ the King, of Christendom, right? And all of these nations, these just rulers, submitted to the Pope, and we had this unified Catholic theology, right? Kind of like the secular, perhaps satanic concept we have now of the rule of law. This abstract rule of law that heaven knows where it comes from, but it's this objective thing in the ether somewhere that we're all attaining for, and the United Nations has got it figured out, and we just need to submit to the rule of law. Law is above people. There are no distinctions, equality under the law. That whole secularized concept comes from the concept of Christendom, which actually meant something. So that's one thing to take away. Second thing to take away is one major political and legal question at the time of St. Thomas Aquinas was, is this law in the Old Testament still valid law? Or has it changed or been abrogated? So he talks about the changing state of that people, the changing state of the Jews. Mutato statu ilius populi. The judicial precept, this is St. Thomas Aquinas speaking now, the judicial precepts which men have instituted are of permanent force, as long as the state of regime endures. Manente illo statu regiminis. But if the city or the active part of it comes under another regime, the laws must change. For the same laws are not appropriate in a democracy, which is the power of the people, and in an oligarchy, which is the power of the rich, as the philosopher makes clear in his Politics. The philosopher obviously being Aristotle. That's the end of St. Thomas Aquinas' quote. Aquinas' ideas were carried to the Italian cities by his Dominican pupils, Remigio di Girolami. That's funny. That reminds me of Gorlami. And Ptolemy of Lucca. And his scholastic abstraction of Aristotle's different constitutions turned out to be a perfect instrument for understanding the volatile chemistry of city politics, the transformation of one regime into another under the strains of the party warfare of Guelph and Ghibelline, and of economic and demographic growth. Another big thing to point out, St. Thomas Aquinas was a Dominican. The Dominicans are, in order, started by St. Dominic. It has 4 pillars, and one of those 4 pillars is scholarship. This idea of medieval scholasticism very much comes from not just Thomas Aquinas, but the entire milieu surrounding St. Thomas Aquinas and his Summa Theologica. So interesting that these medieval lawyers and philosophers, they are the foundation of everything we take for granted in politics. Oh, excuse me, I skipped a page here. Already in the early years of the 14th century, Aquinas' admirer, Dante, could write in the Inferno of the town of Cesena in the Romagna as suspended between tyranny and a free state, tra tirania e stato franco. And the Florentine historian Giovanni Villani called the constitutional reforms of 1293, which attempted to curb the influence of the magnates, a mutazione di Stato. Both Villani and Leonardo Bruni, who described the results of the Ciompi revolt, in 1378 as status republicae mutatio, were using the terminology of Aquinas, along with the argument of Book 5 of Aristotle's Politics, which discusses the transmutation of constitutions. So, St. Thomas Aquinas, Summa Theologica, Dante, not just the Inferno, but the Divine Comedy in whole, and Aristotle's Politics. Write all those down, buy them and read them. Honestly, I don't know Giovanni Villani or Leonardo Bruni. I have not read their works, but perhaps they're quite influential. The next section here is State as Commonwealth. Let's see what we got here. Make sure we're still streaming, because I'm terrible at that. All right, doing good. Audio's good. Need a tech guy if anyone wants an internship. So all 8 of us in the room for this epic reading about medieval law. Odysseus, to the library. Come on, time to go.
Yeah, it's time for you to go.
State as Commonwealth. But talk of the state of the regime has always been in relation to that wider community, of which the regime is the focus. As historically important as the idea of the organic nation is that of the political ordering of ranks or estates into the state of the Commonwealth, a benign vision perfectly represented by H.A.L. Fisher's description of the outcome of the Norman conquest of England. Quote, "The foundations were laid for the construction of a free and well-governed state. Normans and English intermarried. Under the shelter of a government strong enough to keep the baronage in its place, a rural middle class, that valuable feature which most sharply distinguishes medieval England from its continental neighbors, maintained itself in rude comfort and respectability, and in due course of time became a principal pillar of constitutional government in our island." Obviously, Fisher is English. So this is one of the things we talk about quite often on this program, because we talk about legal news, current events, we talk about Anglo-American tradition, and we talk about the common law. We also talk about the common law in contradistinction to the civil law or prescriptive law. We talk about natural law, and one of the biggest illustrations of this is the Norman conquest of England. When William the Conqueror conquered England in 1066, he, of course, as the ruling invader, had to implement laws. However, he kept in place the old laws. This was the common law. So the example I always give is, if a pig used to cost 10 shillings, well, in a future case, if a pig is stolen and the custom was that it cost 10 shillings, and a previous case said it cost 10 shillings, then that's what you're going to be ordered to pay, is 10 shillings. You're going to keep that local custom and local law in place while you are issuing laws from the throne, now that you have conquered England. So now we're talking about how the Normans and the English intermarried, and how the nobility maintained itself in medieval England. The state which Hegel made, this is no longer Fisher, this is back to the book, the state which Hegel made the subject matter of history is a much more dynamic maelstrom of external contingency, and the inner particularity of passions, private interests, and selfish ends, abilities, and virtues, vices, forces, and wrong. Society was held together by the fundamental sense of order, which everybody possesses, but the origin of the state is domination on the one hand, instinctive obedience on the other, because obedience and force, fear of a ruler, is already a connection of wills. I can hear Odysseus howling in the other room. Beowulf. In fact, the Aristotelian analysis of regimes assumed from the first competition for power between social groups within territorial boundaries. It is for this reason that some references to state as regime appear ambiguous and capable of signifying both regime and commonwealth. You recall earlier episodes of our program, here at Crime and Punishment, where we talked about Carl Schmitt. We talked about the nomos of the earth, right? The concept of law now, in modern times, as this, we'll just look up these statutes on the internet and look up this case law and try to fit it into what we want to argue in this case, and poof, you're going to have this mix, this porridge of thing we're going to call law. This garbage in a bowl. This is what law is. It's the will of the people, and they pass laws through their representatives in the legislature, and then an executive signs off of it. We all agree. Well, most of us agree. Well, some of us agree, but it passed anyway through special interests. But that's what law is. No. Absolutely not. Law is tied to the land. It is not some abstract concept that comes from God knows where, Westlaw, LexisNexis, former cases, legal arguments in some obscure document. No. Law is tied to the land. There are boundary markers in stone, on actual soil. That is law. You cross that boundary marker, there are going to be consequences. Real life consequences. Like, You will be taken into slavery. You will be whipped. You will be killed. You will have to pay for your trespass. Monetarily, physically, something. That is law. Something very visceral, something very real, something tied to the land in real life. And that is the distinction that Carl Schmitt was making about ancient law versus modern law. So in Aristotle's time, naturally, they're assuming that we're talking about competition for power between groups within a territorial boundary. That's something real, right? But then you get along and time passes and you've got these muddled theories, and all of a sudden you're like, well, what exactly is a state? What exactly is a regime? What exactly is a commonwealth? We have commonwealths in America and states. What does it mean anymore? Commonwealth of Pennsylvania, Commonwealth of Massachusetts, state of Florida, state of Arizona. So they're interchangeable now. They're all muddled. Machiavelli, back to the book, was led to use stati for whole countries when he applied the analysis of regimes to the great territorial principalities of his own time. When, for instance, he contrasted Turkey, which he described as governed by a single ruler and his servants, and therefore difficult to conquer but easy to hold, with France, where the barons also had territories and subjects in the state was easy to capture piecemeal, but was difficult to hold. Which calls to mind in a more modern example when that Japanese general was talking about, well, if we invade America, there's going to be a rifle behind every blade of grass. That's the distinction between a tyranny and a republic, or a principality rather, which can devolve into a tyranny, as they're arguing in this book. The difference being, in a principality, it would be easy to conquer because there's a focal point. I'm sorry, difficult to conquer because there's a focal point. But once you do conquer it, then those people are already used to obedience. They're already used to that central focal point. So if you're just swapping out focal points, well, then it's easy to hold that territory. No one's going to rise up and fight you. They didn't rise up and fight the last guy who was in that position. However, if you're fighting a republic, where there's not a strong central leadership in the same sense, then maybe you'll take it over more easily than you would the monarchy or the principality. But once you do, man, you've got a lot of people who are going to be mad. A lot of people who don't want your foreign influence there. A lot of barons, a lot of landlords, a lot of people who own things, a lot of people with vested interests in keeping the old order of things. So it's going to be tough to hold that because they're all going to fight to drive you out. Machiavelli talked about this at length in The Prince. It was in territorially extensive communities such as France, England, and eventually the new United States, not in the Italian cities, that the relationship of the regime to the wider state would come to be seen as problematic. Montesquieu, Adam Ferguson in 18th century Scotland, and Alexander Hamilton in a newly independent United States all saw a limit to the geographical size of a state which could operate as a democracy. I have to close the door. He's making a lot of ruckus. There was perhaps a certain natural extent within which the passions of men are easily communicated from one or a few to the whole, and there are certain numbers of men who can be assembled and act in a body. The 18th century philosoph's concern with the territorial limits of a viable political state was overshadowed, however, by their growing conviction that human society as a whole developed through successive states or stages, a process which has been termed legal evolution, because each stage was believed to be marked by a transformation of laws. In his Spirit of the Laws, published in 1748, Montesquieu explained how the law in general, which governs all the peoples of the earth, was fitted by positive lawmaking to the character of a particular people and the climate and terrain of their country to produce the civil state. We are told, for instance, how St. Louis, the great 13th century king, adapted Roman law to the needs of France in his établissement. I don't speak much French. Interesting that he would call him St. Louis. Not Louis, I think, the Ninth. But he calls St. Aquinas just Aquinas. Here we go. Once more, it is Aquinas who gives the first theoretical recognition of a basic political reality. The most obvious source of the concept of the status regiminis is the status regis politicians attributed to kings. Regis meaning of the king, rex being Latin for king. Of course, as a schoolman, relying on ancient authorities, he does not attach his state of the regime nor his concept of the wider state of the Commonwealth to any 13th century kingdom, but to the kingdom of the Jews as it developed through biblical history. Yet he joins Commonwealth to king in the way that, as a teacher in Paris and privileged observer of the rule of Saint Louis, he must have known a contemporary kingdom was joined to its ruler. The context of his references to the state, it will be remembered, as a discussion of the relationship of the Old Law to the New. Old Law and New being capitalized, meaning the Old Testament and the New Testament. The Old Law of the Jews and the New Law of Christ. He argues that the moral precepts of Old Testament law retain their validity for Christians under the new law of the gospel, and that even the ceremonial precepts, of which the literal or historical purpose had been to keep the Jews from worshipping idols, still have meaning for us, in that they prefigure the relationship of man to God through Christ. The judicial precepts, the working laws, were specific to the Old Testament community, however, and intended only to order the state of the people of the Jews according to justice and equity. Thus they have no authority among Christians. Yet, even the judicial precepts may have something to teach later ages, in that they set out the whole state of that people, which prefigures, one might say, provides a model for subsequent states. So that is the long answer as to whether the Old Testament law is still valid or not. In a nutshell, no. But it is instructive. For Aquinas, the essential nexus between the regime and the people was legislation. He understands that the legislative function will be exercised in different ways in different communities, and that this indeed is how a monarchy with its constitutions of princes is distinguished from an aristocracy, in which the law is made by the decrees of the Senate and the opinions of an elite of jurists, and, finally, from a democracy, which legislates by plebiscite. You know what? I'm going to start calling the Congress the plebiscite. Bunch of plebes in the Senate and House. We are governed by a plebiscite. Not only the legislative process, but also the content of the law, and therefore the character of the wider state, is determined by the nature of the sovereign power. If a city comes under another regime, its laws must change. For the same laws are not suitable to a democracy, in which the power belongs to the people, and in an oligarchy, in which the power is of the rich. So when the state of a people changes, mutatus statui lius populi, the judicial precepts must change. This calls to mind another concept. So he's saying that... Are you playing Altar Server? Is that what you're doing? All right, let's play it quietly, all right? So he's talking about how the character of the people, the nation, the land here, this is going to change when you change the laws. Lex orandi, lex credendi is another concept it brings to mind. The way that the law of prayer is the law of belief. So the way that you pray, the rituals in which you engage, that determines how you believe. This is one of the arguments of traditionalist Catholics, the RTCs, the FBI calls them, the radical traditionalist Catholics. Lex orandi, lex credendi. The way that you pray is the way that you believe. So if you, for instance, stand to take communion, and you walk up to the priest and you put out your hands and you take communion in your own hands and you put it in your mouth and you walk away like you're just picking up an ice cream sandwich from the ice cream truck. That is going to determine the way you believe. You're going to think, this isn't at all serious. This obviously is not the body of Christ. It's a piece of bread. We're just taking it, as a symbol of communion with this wider community and possibly with God, I suppose, but you're not really thinking of that. You're thinking about, man, I got to call the accountant as soon as I get out of here, and Jeff has to get to his baseball game tonight. And in contradistinction, if you approach the communion rail and you kneel, and the priest places the host on your tongue, and that is the way you receive communion. That is the lex orandi, the law of prayer. Then your lex credendi, the law of belief, is going to be completely different. You are kneeling and receiving on the tongue because you believe that this is the flesh of God himself. And this is an awesome event in which you are taking part. And each time you take communion, your belief system is going to be completely different. And I think that's an apt analogy to make here, because we're talking about Saint Thomas Aquinas, whose most important work is his work concerning the Eucharist, right? He's the same guy making this distinction that if you bring in a new political regime, then the constitution of that country, your moral fabric, everything you believe about a state or a nation or whatever you've got, it's going to change radically. So if you have a monarchy, like England had, for instance, you're going to have a completely different country than if you have a constitutional monarchy or a democracy or a republic like England and America and everybody else has now. You are going to have, actually, here, since you've got your pens out and you're writing all these references anyway, write down Ernst Kantorowicz, The King's Two Bodies. Actually, Professor Chad Pecknold just mentioned that, I think, in last week's Catholic Political Thought course. Excellent book about medieval philosophy and what it means to have a monarchy, where the king's two bodies refers to the king has a physical body, but he also has the civil body. The land is the king, right? I think Hans Hermann Hoppe talked about that too in the God democracy, the God that failed. So when the king dies, that's why we say the king is dead. Long live the king, because the king, the office of the monarchy, the king as a grander concept lives on. We have nothing like that in a republic. So in a state like that, you have this concept where the king is this, almost mythical figure. He is there by divine right. The king is the defender of the faith, right? He is the defender of the realm. He has all these glorious titles, and people look to him as the standard for what a human being should be. Now, skip across the ocean here in a couple centuries and look at America. Does anyone, even the people who voted for him, think of Biden in that sense? Even the people who, idolize Trump, I don't think even they would pretend that we're talking about the same concept here. Although there are some people who would meme him into being king, this concept that he is here by divine right and that he is the defender of the faith, no. You can't compare somebody like Trump, even with the cult following he has, with, I don't know, just name any king. King Henry II. Right? Can't compare. The culture of America based on this concept that we just vote people in and out every 4 to 8 years, and power's going to change and the laws are going to change, the pendulum's going to swing, and nothing really means anything, and segregation and desegregation and trannies in the bathroom, and conservatives are banning drag queens. All that's just illustrative of having this form of government that we call a democratic republic. Whereas knights going off to the Crusades and, great works of art, all of those things that we take for granted about medieval Europe, it's because of the form of government that they have. So that's the argument being made by Aquinas, who's the same guy whose most famous and most significant work is about the Eucharist. That's why I think that analogy was proper. For all you non-Catholics wondering where I'm going with that. For the idea that human societies, back to the book here, Christendom as a whole changed their states, Aquinas could have drawn upon both sacred history and Roman jurisprudence. When he argues that there cannot be a third status mundi after the state of the new law, though by the grace of the Holy Ghost that law may be kept more perfectly, he was adapting a Trinitarian scheme of history, propounded most recently by Abbot Joachim of Fiore, who died in 1202. But it was really as one of the post-glossators of Roman law that Aquinas wrote his lengthy treatise on law in the Prima Secundae of his Summa of Theology, as the first, indeed, of the jurists who moved on from the glossing of the text of the Corpus Juris Civilis, to the writing of coherent books of their own. He would have known Ulpian's dictum in the Digest, Publicum jus est, quod ad statum rei Romani spectat, that there had been a state of Roman affairs, res, as in res publica, which is where we get the word republic, enshrined in a law which governed public ceremonies and the magistracy. He might have read Justinian's Constitution Tanta, which promulgated the just completed digest of Roman law on 16 December 533, and proclaimed that God had set the imperial dispensation at the head of human affairs precisely to cope with novel contingencies. Human society was created and sustained by acts of lawmaking. Aquinas goes to some pains to show that even the eternal law of God has its source in legislation proceeding from his reasonable will, even if a law existing from eternity cannot have promulgated in the normal way. Imagine a modern legal philosopher speaking in this manner, that not only is there a natural law, that is a reflection or emanation of the eternal law of God, but God himself legislates, and this is how he orders the universe. It is legislation that gives us the eternal law, legislation by the one divine king. From that we have the natural law. No. Are you kidding me? I remember, well, I'll just skip that illustration, but the modern concept of law is completely antithetical to this. The modern concept of law is Mothers Against Drunk Driving really hates drunk drivers. They're going to go up to Tallahassee. They're going to lobby the state senators and the state house representatives and the governor, and they're going to try to get this legislation passed. They had someone draft a bill. They want you to look at it. That's law. It's special interest group, and I have nothing against Mothers Against Drunk Drivers. Don't get me wrong. But that is our concept of law now. We have a special interest. We're going to draft a bill. We want this to become law, so we take it to the Capitol, and we try to sweet talk and strong arm everybody we can until we get enough votes, and boom, now you've got a law. What a radically different concept than actual divinity, than a holy person who has a divine right to be on the throne, issuing a law that is good not just for his country or for his special interest group, but for the natural law established by God himself. What a radically different concept. And so what do you think the cultures of, say, a country like that and a country like ours are going to be? So everybody wants to talk about, the influence of the Jews and the, special interest groups and the, whatever, man. They're putting stuff in our food, and there's chemtrails and every theory on earth, and none of them end up where they should, which is a question of justice, of holiness, of righteousness, a spiritual question. Why is America completely spiraling down a toilet drain right now? It's not just conspiracies. It's not just, inimical parties in their host country. It's not about any of these things that we bicker about on Twitter. It's a question of divine law and our complete separation from it. At least that's what St. Thomas Aquinas might say. Where was I? Similarly, human laws proceed from the reason and will of the subordinate governors. So we're back to that concept of the eternal law is legislation by God. right? That's how he creates the world and orders the universe. Similarly, human laws proceed from the reason and will of the subordinate governors who derive their plan of government from the supreme governor. That's capitalized. That means God. But have always to be adapting it to the changing states of their particular societies. His assertion that any rational individual... Oh, excuse me. We're at 1600. We are over time. And this just keeps going for a lot longer. It's like a paragraph or two. Let's just go over. His assertion that any rational individual is legislating, being provident for himself and others when he applies the natural law to his own particular circumstances, and his description of emergencies, ex ante gratia, threats of military attack, or the starvation of one's family, when the ruler or an individual may tax or steal on the principle that necessity knows no law, show that Aquinas' lawmaking is a practical exercise. On those occasions that he quotes Justinian's Digest directly, it is to emphasize that only a manifest common utility justifies changing human laws. The force of law depends on its stability and rootedness in the customs of the community. Whew. Again, what a radically different concept. That's pure Catholic Carl Schmitt right there. That is ancient law. Law tied to the soil. The force of law depends on its stability and rootedness in the customs of the community. It's not some prescriptive legislation coming out of The Hague in the Netherlands, or Brussels, or New York City. It's not, some declaration of human rights that we're going to impose on every country and every community in the world. It's the force of law depends on its stability and rootedness in the customs of the community. Hugely different concept. But in the late 12th and 13th centuries, kings were taking it upon themselves to guard and purge these customs, and to mold the societies of their countries by positive legislation, as distinguished from what Aquinas is talking about. And that's one of the gripes we often bring up on this program. Positive legislation, legal positivism. We can just make stuff up and make it law, whatever we want. You are now ordered to do this, peons, having no basis in reality. Just, this is what we want. This will be law now, completely divorced from the natural law. That's the danger of positive legislation, legal positivism. In the 1250s, back to the book, the kings of both France and England began to talk of the purpose of this lawmaking as to correct the state of the realm. In 1284, Edward I, king, claimed divine providence as his guide for the new order he decreed, statuendum decrevimus, for conquered Wales, echoing Aquinas' dictum about subordinate governors who derive their plan of government from the supreme governor. By the second half, that supreme governor is lowercase, by the way. So the subordinate governors under Edward, right, derive their plan of government from him, from Edward. By the second half of the 13th century, there existed an idea of the territorial state structured by law, which could be used by practical administrators as well as theologians. The following chapters will trace the building of a model of the state out of the systems of legal procedures and law courts, acts of legislation, and definitions of public crime, private property, and injury, which had begun to appear in the Germanic kingdoms that succeeded the Roman Empire in the West, and show how it reached completion as an arrangement of legally differentiated estates that included the king and embedded the regime in the Commonwealth. So, no comments I see, so we can safely begin the exit music. Thank you all for checking in. Let me know if you want to do a part 2 of this next week, or whether we should get back to the news. Till then, everybody.